Hello, and thank you for returning to my video series, Indicted and Facing Prison Now What? My name is Mark Blatstein. In 2006, I too was indicted and convicted of a felony, losing my medical license to practice. To call that a life-altering event, like all of you are going through, at best, was an understatement and is an understatement. With work, though, after release, I was able to get my medical license reinstated in full in 2010. My takeaway lesson is that prison is going to be temporary. And so almost from day one, you need to be preparing for going home. And what are you going to do? Are you independently wealthy, or are you going to have to work? Or are you retired? Do you have to care for another spouse, or you have to care for a spouse or a loved one? All of these are important because it's going to go into your personal narrative that lets the judge know who you are, the release plan that the judge is going to want to see also, and will get you out as soon, possibly quicker, and the allocution, which is your conversation with the court. But I digress. The goal in this series is to provide you with the information needed to survive and navigate these times, because knowledge with preparation is going to help you build back the confidence you need to get through this process. You've probably already learned that Department of Justice and FBI, maybe they've been asking questions, they showed up at your home or office, or you received a target letter in the mail. Either way, by this point in time, their case against you is mostly complete, and they have a conviction rate approaching 98%. So what you do next, if you delay acting, is going to be at your peril. So what is that? You need to identify and meet a criminal defense lawyer who practices federal criminal defense in federal court. And the hiring this legal team doesn't just mean that you're going to base it on their experience, but they're going to need to give you a proven track record of successfully defending cases like yours. And that's important. Plus, equally important is you need to be comfortable. You just need to be a good fit between you and the legal team. And you only will know that and have a comparison if you've interviewed several. And unfortunately, when something like this happens, you're not at all prepared with legal counsel. But if there's someone with a clearer head with you, a spouse, someone else, then you can begin to like develop a plan. And developing this plan provides you with knowledge and preparation, and that's going to begin to build you back confidence. The choices then you're going to making today are going to help you in tomorrow. Should you have these questions, please do not hesitate to call and consider engaging my services at 240-888-7778. This is your life and your future. I've come through it, and I'm attempting to show you a pathway where you can get through yours with the least amount of discomfort. It's crucial to thoroughly review your presentence report before it goes to your judge and it is considered official at your sentencing hearing, because you need to ensure that all facts are represented accurately. If you find misrepresentation of facts, it's important to catch them and then request that the probation officer correct or add the new contact before your sentencing hearing. This is a common procedure. All attorneys are familiar with these, as errors and inaccuracies in pre-sentence reports can happen. I will say that I think it happens less if you give all the information that the officer needs in a personal narrative before you actually meet them. And if your attorney on their first meeting begins to explain, your case and their strategy to the probation officer so that they can have this information in advance before the prosecutor gets to taint them and give them a bias against you. Because probation officers, they work hard, they're overworked, have no time, and they are a third party. They represent the court. They don't represent prosecution or defense. Then your pre-SR is an essential document that provides the court with a detailed overview of your criminal history and the role in the offense, and other factors will impact your sentence. So by providing your personal narrative before you meet the probation officer at your pre-sentence interview, if you give them all that information in your narrative that they're going to need to fill out their pre-sentence report worksheet, this will diminish, not get rid of, but diminish some of the chances for mistakes. You don't want to let mistakes or things you don't agree with move forward. If you're already at this point and don't have the time to wait for future videos, please give me a call and we can discuss your situation one-on-one. Once again, my number 240-888-777-8. Very easy. 240-888-7778. It's important to note that your pre-sentence report, once final, is now considered under seal, which means that it cannot be accessed for anyone other than the court and other authorized personnel, such as your judge and the probation officer, the prosecutor, case manager, unit team, and warden. There's no guarantee, though, because now in the age of internet and everything is available online, mostly, for someone who's able and has the resources to look, it's possible that someone could identify what's in your pre-sentence report, but you are not allowed to bring it with you into the prison. As I say, this is not entirely accurate, as anyone with internet access can learn a lot if they know where to look. And unfortunately, with contraband in prisons, people have smartphones. Smartphones can access the internet. It's crucial to include a narrative that provides additional context regarding the details of your case and of your life's history, your story, to ensure that your pre-sentence report accurately reflects your circumstances and mitigating factors that could be applied. Your narrative should include the information about your role and nature and circumstances of the offense, as well as your personal history and characteristics. And you can Google all of this under 18 U.S. Code 3553, where it explains it very clearly. And you can use that outline as you begin as part of your narrative, not as your whole narrative. By attaching the narrative and then having the probation officer weaving the applicable parts into your pre-sentence report, as well as attaching your personal narrative as an attachment to the report, is the only way to ensure that it becomes part of your permanent file and it will follow you for the rest of your life. But without your narrative attached to it, that's all that stakeholders are going to be able to read. And so which would you prefer? I guess the question is, without it, are you happy having your indictment speak for you without you saying or writing anything? To engage my services or have your concerns answered, call me today, 240-888-7778. This is my personal cell, and I personally answer and return all calls. Also, you can get all the information you need for free on my website at pprsus.com. P as in Paul, P as in Paul, R as in Robert, S as in Sam, us.com, otherwise known as Physician Pre-Sentence Report Service. I appreciate you taking the time to listen. I hope it was helpful, and have a good day.